the fact of the matter is, ultimately what happened here is that Judge Piet Kuhn actually made a very, very good order. Let me explain by means of an example. What happened here is he decided, on face value, what was presented to him by the legal team of the defense was a medical certificate indicative of some kind of health issue with the former president. Now, on face value, that is the evidence available to him, and he had little but choice to postpone the matter accordingly. But what happened is, simultaneously, knowing very well that we've seen in the past a delaying technique, the Stalingrad technique, used by the defense especially, to delay the proceedings ad infinitum, as long as possible. Knowing that very well and having that in mind himself, he decided to scrutinize the validity of the medical certificate. That's why he postponed the matter to the 20th of August 2021. On that specific day, he requires the defense to provide him with a complete report, not only a one-page medical certificate, but a report indicating exactly what the health issues is regarding the former president. Now, he went even further than that, but this was on request by the state advocate, requesting that the court should also make an order that the state will have the prerogative to appoint an expert, a medical expert of their own choice, to scrutinize the report and the arguments and the evidence of the defense in this regard, to even basically have their own investigation regarding the health condition of the former president. And by all means, if both of them concurs, both are in agreement, then that is the situation. Sorry, okay. There's something happened there. What I was saying is that if that is the situation, and if both experts conclude that he is not in a healthy position or in the position to stand trial currently, well, then there's unanimous evidence before court to make an informed decision once and for all. That's now the judge. But if there is a discrepancy, then the court must do, like they always do, decide one of the two versions. Obviously, the one that has the most credibility attached to it, which weighs the heaviest in the eyes of the court. And that all depends on who is going to be used as experts, medical experts, and obviously the contents of those reports.
Is the legal team of former President Jacob Zuma to be blamed for the fact that this case is on the surface, from the looks of it, being dragged out?
Well, everyone suspects that whatever the defense do these days have some kind of a delay factor attached to it. That is the general feeling in the public. But like I said, it's not as simple as that. Because if it is true that the former president is really and definitely in such a situation that his health will not stand a drawn-out trial of the nature that we are currently seeing and that will be forthcoming in this corruption trial, then unfortunately the law says then the court must make a determination and an order which also protects and takes care of the accused, because he's got human rights and legal rights in accordance to the Constitution as well. One of which is that in ordinary circumstances, your accused, especially in criminal trials, in comparison to civil matters, must be entitled to once and for all be in court, face his accusers, and be in a position to scrutinize the evidence forthcoming from the side of the state. So it will be an unsound principle to finalize the matter, especially in the absence of the former president. Although even that probability also exists if all else fails. But that is the last resort and should not easily be enforced by the presiding officer.
What should we make of the different versions of Mr. Zuma's illness? The one by the Jacob Zuma Foundation itself, the one by correctional services and the one by the doctor from the military medical services?
Well, my personal opinion is that somewhere in the middle is probably the truth. I will not, if I was in the position of Judge Kuhn, easily accept either of the two versions. What I would do is, as he has indeed, and as he will probably do, request both sides to provide him with evidence under oath by means of affidavits. And then I will scrutinize it, and I will give both parties, the state and the defense, the opportunity to investigate and even to cross-examine on it. I will look at the corroborating evidence if there are such evidence available, whether it's by means of supporting documentation, etc. And then ultimately, I will make up my mind. Which of the two versions should I accept as the truth? I will reject the other version. But maybe even in this instance, somewhere in the middle, you will find the correct answer and the truth. Neither the one of the foundation, nor the one that has been placed before court by means of a simple one-pager medical certificate. But fortunately, our judges are experienced legal practitioners. They are educated in law. We've seen similar situations from the days of the Romans and the Roman law for over 2,000 years. That is exactly the same questions that presiding officers faced over the years. There are two versions before court. Sometimes it's the plaintiff, sometimes the defendant, the accused, or the state. And somewhere in the middle, you might find the truth. And the court's main principle and task is, especially the presiding officer, to distinguish between the truth and unreliable evidence and lies, ultimately.
South Africans are getting worked up about former President Jacob Zuma's case. They want to see him put away in court for a long time. But we have a man here that is 79 years old and apparently not in a very healthy state. Yeah. Will that be the best solution for us? What do you think?
Now, you know what? I think the word you're looking for is frustration, because that is what I encounter from members of the public. They are frustrated by the current delaying of the matter. The problem is, even if we start the trial immediately without all these interlocutory interventions, as we've seen of late, then we might still run into a year or a 2-year trial. And I'm only referring to the court of first instance now, being the Pietermaritzburg High Court. After that, either party, the state or the defense, can decide to appeal to a full bench, ultimately to the Supreme Court of Appeal in Bloemfontein, and even to the Concord as last resort. Not even to talk about possible review applications as a result of some kind of irregularity that was identified somewhere between now and when the last evidence is laid in court. So that can take up years on end. By the time we are finished with this incident or this matter, in reality check, we are looking at somewhere in these mid-80s. I mean, we've seen it in numerous occasions. We've had this Shabir Sheikh example, to name but one, and there are many others in the South African legal fraternity and sphere, precedents to be looked at, suggesting that a court will not eagerly insist that a person of such an old age be incarcerated for the remainder of his life. And by that time, I'm sure that if he has not health issues currently, he might be then of such a high age that health issues are part and parcel of his making, and in which event he will then be set out on medical parole, set free. So to say that he will spend a day in court, in jail, incarcerated for his corruption, alleged corruption, might be something that everybody hopes for, but in reality speaking, I do not see that happening very soon or very easily. That being said, maybe somewhere between what the state wants, the long-time incarceration of the former president, and what some of his supporters want, his total freedom, lies the answer. Shouldn't the state consider approaching the defense and ask them for a plea and sentence agreement to get some kind of an arrangement between the two parties? Instead of pleading guilty to the main charge and asking for 15, 20, 30 years incarceration, maybe the state should consider offering a guilty plea to the defense on a certain number of the charges, or maybe some competent verdicts on the main counts in lieu for a reduced sentence. Then both parties win. The matter is concluded. We save taxpayers' money. We save human resources. We save a lot of years of litigation. And the state gets a conviction. He gets a criminal record. The defense will not see the old man incarcerated for the remainder of his life until the date of his death, but at least some substance and some time spent in jail should form part of such a sentence. But it can be negotiated. And ultimately, the rubber stamp, the ultimate decision lies with the presiding officer to determine whether justice prevailed. So it's not only a mere situation that the prosecution can be bribed for a reduced sentence and things like that. The judge must ultimately also intervene and say, but listen, I'm satisfied that on this agreement that I see in writing before me, it's literally a contract reached between the state and the defense. I'm happy that justice has prevailed. In the USA, 99% of the matters, if I am correct, and I think I am, currently gets finalized exactly on this principle of plea negotiations. We've done it all over the centuries in this country, although a bit informally. These days, there is a procedure, Section 105, capital A of our Criminal Procedure Act, that makes provision for a formal written plea and sentencing agreement. But if we want to go that route, that must be done before we finalize the plea proceedings, because once that is done, it's not an opportunity available in law anymore. So the state, if they want to consider such an option, must do it, and they must do it very, very fast and quickly. Otherwise, we've missed that bus, so to speak.